Good afternoon, everyone. Thank you all for coming. For those of you who don't know, I am Dan Puchniak, and I'm a professor here at the Yong School of Law. I'm also the director of the Center for Commercial Law in Asia. I'm excited about the session today. As I suspect everybody in this room knows, in Singapore, if you look at the listed companies, on the SGX, you can divide them into two categories, right? You have the very biggest capitalized companies, government-linked companies, GLCs, where Temasek, right, is the largest shareholder. And then you have the vast majority of companies on the exchange that are family companies, right? But what both of these groups of companies have in common is that they have a controlling block shareholder, right? And this makes both the regulation of these controlling shareholders extremely important in the Singapore context. It also means that for small shareholders, the question is, can they have a voice in these companies? And how do they exercise their voice in these companies? Of course, if you signed up today, you'll know that we're not going to be talking about Singapore. We have had talks here, and I have given talks on shareholder remedies in Singapore. But today is a different focus, right? It is a comparative focus. And we're focusing on the two largest economies in the world, and we're looking at two very interesting things. In the US, right, we're going to hear about the regulation of controlling shareholders, and I won't steal Professor Jill Fisch's thunder. If I tried, I don't think I could do anyways. But I will introduce her in a second, but she is truly the best voice to hear about this from. But it is also an exceptionally interesting time in the US in terms of Delaware and controlling shareholders. And so I think it's going to be a really real treat to hear about the US situation today. The second part of today is going to go to the other largest economy in the world, which is looking at China, right? And China is maybe the opposite in some ways of the US, right? The US, most of the time, people think of their listed companies as having dispersed shareholders, right? That is sort of the stereotype in the United States. Although when you hear about Tesla and Elon Musk and the tech companies, you realize there are some very important companies in the US that are controlling. But China is the other side of the coin, right? I think most people look at China and they say that this is dominated not only by controlled companies, but by controlled companies where the government is the controller. And what myself and my good friend and colleague, Zhang Wei, have done research on is about shareholder activism in China, something which I think does not pop into the imagination of anybody's mind when they think about China. So we have two quite exciting talks and based on exciting research today. The way that it's going to work is Professor Fisch will present her paper, and then Zhang Wei and I will present our paper, and then we'll reserve about 15 minutes for some discussion and some questions I hope can be generated throughout the talk. But before Professor Jill Fisch gets up here, I just really want to welcome her to Singapore. As I mentioned before, Professor Fisch is the Saul Fox Distinguished Professor of Business Law at UPenn Carey Law School. When I say that she is truly one of the best people, not only in the United States, I would say in the world, looking at corporate and securities law. This is not just based on the fact that I have grown to really learn from and love her scholarship. Like any academic, we have hard data to look at. Yeah? And if you look at the hard data in terms of citations, the US has this interesting tradition where they vote for the top 10 articles, and Professor Fisch's articles regularly appear there. Indeed, she is one of the most cited academics in corporate law in the United States, period. Yeah. But for the practitioners in the room, and I know there's a number of practitioners, there's another aspect to Professor Jill Fisch's work, which I think should interest you, which is that she has a laundry list of courts that have cited her. I'm not going to read them out because we only have the 1 hour here today, but she is regularly cited by the court. So it's not just academic work, but it is academic work with real world impact, which I find extremely impressive. And I can see there are a few students here as well. Professor Fisch has sort of done the trifecta in the academic world of combining academic work with real world impact, but also teaching, right? And in teaching, she has received numerous awards as well. So with that introduction, I just want to, again, really thank Professor Fisch for coming here to speak to us about controlling shareholders in Delaware. I'm sure I'm going to learn a lot from it, and we're grateful at SMU that you took the time out of your very busy schedule to come. Thank you.
Thank you for that generous introduction, and thank you all for being here, especially after the semester's ended. I really appreciate the audience. What I'm going to talk about today is going to be a little bit of a rush, because I'm going to try and tell you a little bit about a paper that's already been published that you can look up and read the details for yourself, but also how the paper and subsequent events in Delaware are affecting sort of the market for incorporation. And I know the market for incorporation is something that's particularly relevant, not just in the US, but in Asia. Right, you've got this issue with Chinese companies incorporating in Singapore and trying to benefit from Singapore's reputation. I've read about Singapore washing. So there, I think, are some similar challenges in terms of how do you attract corporations, how do you impose meaningful standards without losing those corporations to competition from other jurisdictions. So, the overview of the paper is basically developments in Delaware law that have placed greater judicial scrutiny on transactions involving controlling stockholders, right? The article that we wrote challenges that expansion, and we were quite fortunate because we got this article into print, and barely a month later, the Delaware legislature adopted changes to its law, overruled some of the judicial decisions, made some adjustments that we don't agree with all of, but it was fortunate that we got the article out before the legislative response, and so I'll talk about the legislative response as well. Right. So background concepts: we in Delaware regulate companies with controlling stockholders largely through judges overseeing transactions involving conflicts of interest. And the way judges oversee those decisions is with heightened judicial review. So Delaware has 3 standards of judicial scrutiny. Most business decisions, the courts defer to the board of directors. They apply the business judgment rule. If there's a controlling stockholder, the transactions are subjected to the highest level of judicial scrutiny, entire fairness, which basically allows the court in some cases to second guess a transaction that the board or the shareholders may have approved. Right. So entire fairness review can not be cleansed through either a stockholder vote or an independent committee. But the Delaware Supreme Court a few years ago in the MFW case said, if you use this very heightened procedural mechanism, you can get back to business judgment rule. You can take the decision out of the hands of the courts. Right. Now, brief history of controlling stockholder liability. I said entire fairness is this heightened standard of review. Traditionally, it was fairly limited. You needed a stockholder who had something close to a majority control. And usually you were looking at transactions in which the conflict of interest was super obvious, like a controlling stockholder freeze out. The controlling stockholder is buying out the minority stockholders, right? It's an easy transaction to view as potentially unfair, right? And the courts would look hard at both the process and the price, right? The law starts to change, right? There were some early cases that said, well, maybe it's not just controlling stockholder freeze outs. Maybe we've got more flexible standards of those transactions. Maybe we also have more flexible ideas of control, soft control, not merely stock ownership, not merely voting power, but relationships, potential influence. MFW and the requirement to go through this super onerous standard was expanded to other kinds of transactions, executive compensation, reincorporation, service agreements, right? And the changes culminate in two key cases that were decided over approximately the last year. Right. So one of these, which Dan has already referred to, are Tornado against Musk involving Tesla. Tesla decided that it was going to pay Elon Musk a large amount of money, right? 56 billion, more money than most CEOs get. And what did this court say? Well, a couple of things. First of all, entire fairness applies to executive compensation. Now think about it. Evaluating whether an executive's pay package is entirely fair, that's a hard task for a court. That's different from looking at a merger, at a freeze out, in which you have available benchmarks. It's also potentially expansive, right? Is every company's CEO pay package now going to be evaluated under entire fairness, right? And are judges really very good at determining whether an executive is paid too much money, right? Courts have kind of shied away from that for years, right? So that's one dramatic case, right? Second case, right? This was Delaware Supreme Court, the match case, right? The match case took this idea from the Tesla case and was even more expansive. Entire fairness, the court said, applies to every transaction in which the controller gets a non-ratable benefit, in which the controller gets something that the minority stockholders don't, right? The only way that you can avoid entire fairness is MFW. And the match court said, we're going to make MFW even more demanding, right? Heightened standards of independence for the special committee, right? And in doing so, the MFW court said one of the directors on the match special committee, a director that the company thought was independent, they said that director's not independent enough. Business relationships, personal ties, those are enough to compromise a director's independence. Those taint the committee, and those then cause the transaction to fail, cleansing under MFW, and require entire fairness scrutiny. Right? So what explains these developments? Why are Delaware courts making it tougher for controlled companies to enter into these transactions? There are a few possibilities. One, we see an expansion of controller concepts in the United States. So Dan said, years ago, traditionally, we've all thought of U.S. companies as having dispersed shareholders, and maybe we worry about powerful executives, but we don't have a whole lot of controlling stockholders. Today, that's not true, right? We've got a number of founder-controlled companies, right? Those companies have founders who retain power for an extended period of time, sometimes through shareholder agreements, sometimes through dual class stock. And those founders have big personalities. So even when they don't technically have majority control, Elon Musk at the time of this case only owned about 22% of Tesla, right? But the board listened to him. Shareholders listened to him. Everyone treated him like a controller. Right? So this expanding idea of control made the Delaware courts worried, if everybody's going to just do what the controller says, right? There's potential unfairness and we need to intervene, right? There's also an expansion of situations in which a controller has an issue, right? The ability of a controller to take a corporation out of Delaware if he's unhappy with Delaware law. Elon Musk did that, moved Tesla to Texas. Greg Maffei is in the process of trying to do that with TripAdvisor, right? Transactions between a controller's multiple companies, Elon Musk, controller in Solar City, as well as Tesla. He decided it would be a good idea for those two companies to merge, right? That was potentially a transaction involving a conflict of interest, right? And finally, there were practical problems, right? How do you know whether you're a controlling stockholder if it's not 50%? If it's soft control, if it's transaction-specific control, right? How can you tell? How do you know in advance that you've got to go through some sort of heightened procedural process? MFW cleansing also turned out to be really difficult. You might say to yourself, well, the Delaware courts have come up with a procedure. All the corporation has to do is follow that procedure, right? But it turns out that over half the time, companies don't even bother because MFW is too hard. They're worried about, stockholders not showing up, not getting a high enough vote. And even when they try to go through the MFW process, courts strike it down. Courts say, well, you didn't do a good enough job, the way the court did in Match, right? And the heightened judicial oversight also seemed to a lot of people, including me and Stephen, to disregard other aspects of Delaware law, right? The market seemed to be favoring controlling stockholders. If investors are willing to buy into these companies, why are the courts second guessing that decision? What about the board of directors, right? If the board of directors ultimately has responsibility for these decisions, why would the court intervene, right? And as a practical matter, even a controlling stockholder in the US system has limited power. Stockholders can't make operational decisions. So Elon Musk was powerful not just as a stockholder, but because he was also CEO, he was an executive and chairman of the board, a director, right? But Delaware law in recent years has kind of eroded officer and director accountability. And the courts may have seen controlling stockholder liability as a workaround, as an end run to address that problem, right? So our proposal basically, and I'm going to go through this relatively quickly because I want to move on. Our proposal has two parts. One, we say this trend in the Delaware courts, that should be reversed, right? We shouldn't keep expanding who's a controlling stockholder, and we shouldn't keep expanding controlling shareholder liability. And in particular, we warn against treating people who are acting as stockholders in their stockholder capacity as fiduciaries. Right? The second piece of this is we say, let's pay more attention to directors at controlled companies. And here again, I think this is a concept that's probably going to be familiar under Singapore law. The idea that if you're a director at a controlled company, you're not just a mouthpiece. You have some responsibility of oversight. And that, I think, Delaware law has stopped doing as vigorously as it should in recent years, right? So those were our proposals, right? And our proposals were made at a time that there was also a market reaction to the decisions that I just discussed, in particular the Tesla and Match decisions, right? TripAdvisor, Tesla were not the only companies to seek to leave Delaware, right? It turned out that there were a slew of companies that said, you know what? We're unhappy with what the Delaware judges are doing. We're going to incorporate somewhere else, right? And the somewhere else's, at least for the moment, appear to be primarily Texas and Nevada, right? Delaware panicked. Right? Now, you might say that that's really only a handful of companies. Delaware is the state of incorporation for thousands of companies. What's the big deal? But the Delaware legislature got scared. There was a sort of social media attack on Delaware incorporation. Elon Musk posted on X, never incorporate in Delaware. So the Delaware legislature responded, right? And what the Delaware legislature did is several things. One, it expanded a statutory safe harbor. You no longer need the heightened MFW process. The statute says if you comply with a greatly reduced procedure, right, entire fairness doesn't apply, right? So we're cutting back on that judicial oversight that people thought was burdensome. Number two, when you're acting in your shareholder capacity, you can now be protected as a shareholder in the same way that officers and directors were protected, right? And number three, I said one of the problems with this is we can't tell who's the controller. So Delaware adopted a statutory definition of controlling stockholder, right? And there's a bunch of other stuff, which I'm not going to talk about because I've only got 5 minutes left, right? So some shortcomings to the statute, right? As I said, we're mostly on board, but the statute was written and adopted really quickly. Haste makes waste. I don't know. In any event, there are some things that we think are just a little bit sloppy. Number one, two-step cleansing, special committee, and a shareholder vote is limited under the statute to freeze-outs. Now, as I said, freeze-outs were the worst problem. But it turns out if you're a good creative lawyer, you can come up with a lot of transactional alternatives that look pretty much the same as a freeze-out. Right? Statute doesn't take those into account. Right? Minimal constraints on the independent committee. Right? Rolling back this robust requirement of director independence, but maybe rolling it back a little bit too far. And we can talk a little bit about director independence and what that means. I know that's something that's a constant debate in a lot of Asian jurisdictions as well. Right? And finally, inadequate treatment of contractual control. Right? So in a second article, we talk about the definition of control in SB 21, and we say, you know, what I said earlier about in Delaware law, shareholders can't make operational decisions. Well, that was true until last summer. Last summer, the Delaware legislature adopted a different statute in which it said a corporation can give to a shareholder operational authority through a shareholder agreement, through a contract. Right? So now a shareholder doesn't need to be able to elect a majority of the board of directors. A shareholder can have contractual power to cause the company to enter into a merger, to declare dividends, to sell off assets, to engage in transactions that traditionally were in the province of the board of directors. Right? We view that as something that needs to fit within the definition of controlling shareholder, and that's not in the current statute. So we've got another small article that addresses that problem. All right, finally, right, ongoing issues, right? We don't know whether this new legislation is going to stop the departure of corporations from Delaware, and we also don't know what the right answer is for how to deal with this evolution in the United States of controlling shareholders, right? And here's an issue where I think comparative law can give us a lot of opportunity because the challenges of controlling shareholders may differ depending on shareholder type. Is a powerful CEO more or less dangerous to minority shareholders than a corporate group as controlling shareholder or a government controlling stockholder, right? Those are interesting questions. And how much should we worry about controlling stockholders depending on the institutional structure, right? So the struggle in Delaware, to an extent, is a struggle between controlling shareholders and the courts, right? But there are other ways of either giving controlling shareholders more power or imposing restrictions on what they can do. A lot of European jurisdictions, for example, limit the use of dual class stock. And if a controlling shareholder who has dual class stock can't use that control to affect certain transactions, right? That's a different way of protecting minority shareholder interests, right? Second question, when people are unhappy with where corporate law is going, how should the providers of that law respond? Was Delaware right in changing its statute in order to try to placate controlling shareholders, in order to try and prevent those companies from leaving? Or is this special interests taking over and undermining the quality of Delaware law? People are still debating that question. And finally, are these actions going to allow Delaware to maintain its dominance, or is it going to sacrifice its reputation and cause Nevada or Texas or some other jurisdiction to supplant Delaware in the way that many years ago, Delaware replaced New Jersey as the home for most states of most incorporations? So that I think I got in just under the wire. She didn't have to hold up the wrap-up slide. So Dan, let me pass the baton to you.
Thank you. Well, thank you very much. As I mentioned at the beginning, we're going to have the two papers, and I'm sure many of you have questions for Jill, but if you could just hold them until we get through the China part. Yeah, I was thinking when Jill was speaking that this is like a day of opposites, yeah, because we're talking about controlling shareholders in the United States, and now we're going to talk about shareholder activism in China. Maybe both, you would think it would be in the reverse, yeah. But this research is a project that Professor Zhang Wei and our other co-author, Zhou Chang at Zhejiang University in Hangzhou in China, worked on for, now it's getting on about a year and a half. The title of the paper is called The Overlooked Reality of Shareholder Activism in China, Defying Western Expectations. And we were delighted, we were talking before among us about article placement, and we have this forthcoming in the Harvard Business Law Review, so we were quite relieved it should be out in the next few months, but there's a working paper online. When we start the paper, yeah, we start with this line, right? This is the first line in the article. And it says, China is known in the West for many things. However, a rules-based market for shareholder activism is not one of them. I would say that that is almost a soft statement, yeah? Because when you at least look at the Western media, right, what impression do you get? Right, you get the idea that President Xi Jinping, right, is infamous in the West for demanding that businesses conform to the aims of the Communist Party, right? That is taken out of a New York Times article. From the Financial Times, we took this picture. This picture is to represent the new head of the CSRC, the equivalent to the US SEC, yeah, who has come to be known. His nickname, translated into English, is the Broker Butcher. Yes, for the fact that he allegedly conducted a zealous crackdown on traders in the 2000s. If you think about China, what pops into your imagination is the disappearance of billionaires, right? Of course, the most famous of which is Jack Ma. And then Jack Ma suddenly reappears again in a different form. We all wonder what he was doing for a few years, but I teach regularly at Tokyo University. He's actually on a faculty at Tokyo University. I haven't met him yet, but it's interesting, right? But the impression that we're left with, right, is one that the Chinese government is not only firmly in control, but since Xi Jinping took over, the control has strengthened, It's strengthened through COVID, and that this, in the end, is not a place where you would expect to find shareholder activism, right? And as we say in the paper, this is not exactly an environment in which one would expect to find a vibrant, rules-based market for shareholder activism, especially activism against government companies, right? That is something that would seem almost impossible. And yet, right, we're going to show you that the impossible seems to have become more than possible and has been around for many years. It's not just the popular media, though, that has painted this impression. There is a lot of good, solid scholarship in the Western literature, in the US literature and top journals that has looked at the influence of the Chinese Communist Party in corporate governance, right? And indeed, there are many good scholars who have talked not only generally, but more specifically about the role played by shareholders and institutional investors. To give you just a few, right? Private institutional investors as minority shareholders are likely to remain passive in state-owned enterprises due to political pressure and other reasons. Or an older quote, right? Going sort of a decade before, minority shareholders in SOEs, as described by Nico Hausen, who was not only an academic, but was a practitioner in mainland China, are passive and politically disempowered. Even if shareholders exercise their legal rights, government officials may simply refuse to acknowledge them due to political considerations, right? And it's interesting to think, why was this missed? Yeah. And I don't have a lot of time now, but we draw the analogy in our paper, and it's an old analogy, but I think a useful one in this context, of the person that only has a hammer and sees everything as a nail. If you're looking for politics, you find politics. Now, I want to be very clear. Our research is not making the claim that politics is unimportant. In fact, it's precisely the opposite. Of course, politics is important everywhere. We don't only have to look at China for this. Yeah, we could gaze towards our friends in the United States to find that the political will of leaders can sometimes influence the way that companies behave. So I'm not here to claim that politics is unimportant. Rather, and I'm also not here to claim that all of this research on China and political influence is dead wrong. It's not. Of course, the politics comes into play. The question, though, is how deep does it reach? Does it reach deep down into every annual general meeting on a regular basis when you're dealing with companies that don't have any political skin in the game? Of course, we can anticipate with companies like Huawei and TikTok, okay, that there will be some political interference or involvement. You know, you can look at the financial crisis in the US and what happened with Citibank and Lehman Brothers and these things. Okay, but what we are saying is that there's a bubble. And that bubble is much larger than people realize, of a rules-based market for shareholder activism, okay? And the bubble is something that we uncovered, right? And this is our data. There we go. Yeah, so you can see, right, all the way back to 2007. Now, why do we choose 2007? This is where the split share reform took place in China. This is essentially the start of the free market for tradable shares. And you still find some activism here, right? This is different. There's no English language piece that we could find that even talked about activism at all. So even this part of the chart is a bit undiscovered. But this is what everybody's going to look at, right? 2017, you get this spike. 2017, 18, 19, these are COVID days. These are when the crackdown is supposed to be happening, right? And this is when activism we find is taking off. In total, we have found 156 cases of major shareholder activism in listed companies, some involving the very biggest companies in China, which is what our paper I think, one of the most important things that our paper has uncovered. You may be asking, what do you mean by activism, right? That's the natural question. You're saying activism, but what do you mean? And here's what we mean by activism. We've broken it down into different types. It's not that extraordinary. And you can see the subtitle says extraordinary because unextraordinary. Okay. In the sense that we have shareholder proposals for minority shareholders wanting to put in a nominee director. Okay, that's the biggest one. You have minority shareholders announcing campaigns. Again, we define this as all publicly announced campaigns. So we had to find evidence, okay, that this is public campaign announced against management, okay, and exercising their majority of minority vote, which is interfering with a transaction that management wants to carry out, okay. Other types of shareholder proposals, you do find some litigation, okay, public campaigns, but those aren't that popular. Tender offers aren't that popular. So why we try to theorize a bit in the paper, it could be because you don't have that much development around sort of legal development to make litigation that powerful, where these more direct rights may be easier to exercise, right? What people overlook, okay, if you put into ChatGPT, which I love, it's like my new test to see if I've thought of something new. I ChatGPT it to try to see what ChatGPT comes up with, or Claude, right? So then you see, what will it tell you? It will tell you, if you say, is China's black letter law? Now, if you don't put black letter law, we'll come up with a different answer. Is the black letter law shareholder friendly? The answer is yes. Okay, why? And this is what Jill was talking about in her talk. Delaware is at sort of one end of the spectrum in comparative law, very board-centric, okay? Shareholders don't have, okay, minus what she spoke about 6 months ago, okay, traditionally have had, and still, I think, on a comparative basis, has a very limited right, okay? Maybe contractually now, but if you take out the contractual right, to directly decide on management decisions. China's on the other end of the spectrum. Yeah, Wei was telling me before this, there was one shareholder proposal meeting. They dealt with like over 1,000 shareholder proposals. Okay, management has very hard time blocking proposals from taking place. If the proposals take place, they receive 50%, they are binding. Okay, they're binding proposals. And they can be proposals over a huge amount of what we would consider, even in Singapore. All of you will know Section 157A of the Singapore Companies Act, which places the management authority of companies in the board. Okay, so in China, shareholders have a lot of power. This is often not recognized. You also have cumulative voting, which is required for controlled companies over 30%. Okay, you have a lot of majority of minority vote approvals. You have derivative actions, and on and on. And the most recent amendment to the Chinese corporate law that took place on July 1st, 2024, dropped the percentage you require for a proposal from 3% to 1%. Americans think this is high, but you look around the common law world, it sits at 5% at most places. Okay. And so you can see it's very robust. Okay. And it's becoming more robust. Now, I have to rush through this, but then the big question, and Wei will speak a bit more to this, is, okay, I hope I've convinced you there is activism. Why is there activism? Because there are rules that are being followed to allow this activism. But the big elephant in the room is, if the activism is happening against state-owned enterprises, are all of these cases losing? When the state is, say, a pension fund, state pension fund, and it brings the campaign, is it winning all the time? And so we actually did a proper empirical analysis. We coded the companies, okay, based on whether they're local state, national state, or private, okay? And we found no statistically significant difference in the campaigns when the target was a state-owned enterprise or a private-owned enterprise. In fact, we found that in 78% of activist campaigns against national champions, means the highest level of politically powerful SOE, okay, they were brought by private activist shareholders. 57% of those were successful, okay? Then if you look at it not from the target side, but from the activist side, okay, you get the same thing. Over 50% of activist campaigns launched by powerful national shareholders against the private parties end up failing. Okay, so you're not getting a situation where they're winning every time. And what was quite extraordinary is we found a bunch of cases where private-owned companies faced an activist government shareholder and they used tactics to exclude them from the meeting. Okay, this to me was shocking from a Singapore perspective. If somebody from Temasek showed up at a company and they were not allowed in because of some procedural irregularity, I would be quite shocked. Yeah, so to find this in mainland China was actually quite shocking. We also found what we call it's the legend of the red scarf. It's the roaring kitty of China. And we found this online campaign that took place on a platform. Translation is called Snowball. It's like Reddit, okay, China. They organized a campaign against Costco, you know, the biggest shipping company basically in the world, and they won. They got Costco to pay out a dividend. This is reported all over Chinese media. Of course, you can't fake paying out a massive dividend. It happened. It's unreported. Again, it is fascinating. Another very interesting thing, and I show this slide to remind people how big China is, right? These are all the provinces of China, roughly the populations related to every country. We found intrastate activism, meaning an activist shareholder in one province launching a campaign against a state-owned enterprise in another province. Again, I would love to talk about this more, but we're limited time. But it shows another very interesting thing about, the Chinese state and corporate governance that I think needs to be explored. Why the increase in 2019? Again, in 2019, China changed its corporate governance code to try to invigorate more shareholder activism. They've recently amended their company law to do the same thing, and we say that this dovetails with what we see in our results. Again, I'm going to go 2 or 3 minutes overtime before I hand it to Wei, but I'll just try to close off quickly. We're not saying that politics doesn't play any role. We have a statistical void in our cases, and the void is this. We didn't find one case where a local provincial shareholder ever even attempted a campaign against a national one. This suggests to us there's still a political hierarchy. Of course, it doesn't show up in any regression because there's no statistic there. But we're as honest as we can be, and we're trying to tease out any examples of politics going on, but it doesn't seem to be the norm. So at the end of the day, what do we have here? Yeah, I'm waiting to present this in the United States. This is why I've animated the rise of the Chinese flag. Yeah, what we see here to me is not that extraordinary when you take a step back. Yeah, and here's the point I'll leave you with until Wei talks about our empirical tests for a few minutes, which is, we end the paper by saying there's a reason why the USSR regularly had shortages of toilet paper and why it did not have shareholder activism. China now has an abundance of both, right? And the point we are obviously trying to make is, I always tell people when I talk about this paper, I don't see anybody needing to put 100% tariff on a Lada, yeah, which is the Russian car, because nobody wants to buy a Lada. But you have to put taxes on BYDs, yeah, and you have to do things because why? You cannot create world-leading goods if you're micromanaging every AGM. If that's the case, then really the Chinese Communist Party is truly extraordinary, right? I think the alternative explanation is the more obvious and correct one, which is that actually these AGMs mean something. And there's 200 million retail investors in China, and they get upset when they lose money. And actually, this isn't activism against the CCP. This is activism for the CCP. When you throw out a manager that is not doing their job, or when you get a company to pay out a dividend when the Chinese stock market is not doing well, you're actually performing a policy lever for the CCP. It just shows that they're sophisticated in allowing this to go on, of course, within the limits of what they allow. But we say that space, from what we have uncovered, is much, much larger than what people have suggested in the past. And with that, I just hand it over to Wei, who did the empirical work, just to speak for a minute or two about that.
Thank you. So I think Dan did most of the work explaining our paper. So I'll just try to quickly, walk through these statistics. I think this table is very explanatory. So this just shows, the success rate of the activist campaigns launched by different type of, institutional shareholders with different political status versus the targets also with different level of political status. So as Dane just explained, we categorize both sides, the activists as well as the targets, into three basically categories, depending on whether they are privately owned or owned by a local government or central level government. And I think the simple a story we see here is actually there's no clear sort of difference in terms of the success rates, among different pairs of activists versus the targets, no matter which type of sort of political status each side may has. Then the next. Okay, so this is a regression table. So we did some multivariate regression. So I just want to call your attention probably to 2 or 3 sort of rows here. First is you see this I-score. I-score actually is an index we constructed to indicate the relative political strengths between the activist versus the target. So to make a long story short, here, the greater the index number, basically that means the more the higher status of political status the activist has against the targets, relative to the targets. So what we can see here in the first row is actually, it seems, to show us that once, the activist has a more strengths, political strengths versus the targets, their campaigns are more likely to win because, we see, the coefficient here is positive. So the higher, as I just explained, the higher this index score, that means the more political power the activists have against the targets. So naturally, we'll say in that case, probably they're more likely to win. And this, first row seems to, the sign of the coefficient seems to be, show that story. However, there's no statistical, significance. What this means is basically we cannot tell for sure whether this type of, a positive association is purely something random by chance. And then I would like to show you this, I think, number 4, the row number 4, the percentage of shareholding. Percentage shareholding means, how many shares in the shareholding, the activists have. So, I think it's quite natural if a campaign is launched by some activists who has more shares, more likely they will win. I think basically for 2 reasons. The one simple reason is because they have, more shares, so they can vote for their own proposals. They're more likely to win. But also that also shows the other shareholders in the company, they do have more skins in the game. So it's a way basically to convince other sort of, shareholders to support whatever proposals they may have. So for these reasons, I think it's logical, it's reasonable to expect that the percentage shareholding will be positive again, associated with the chance to win the campaigns. And it is indeed the case in China. And unlike, the I-scores, the, political influence index, these, effects are highly statistically, significant. So there's no chance, basically, this is something, because of the random chance. And then I think the next row here, the ROA, the return on assets of the prior quarter before, the campaign was launched. Why we included that factor, I think the simple reason is because we may expect if the shareholders are unhappy about, the performance, of the company, more likely they will just support whoever challenges the incumbent management. Those are the activists. So if that's the case, we should expect a negative association between the ROA, before the campaign and the chance of success of the campaign, right? And indeed, that is the case if we look at the size of this, the fifth row here. But again, in this table, we didn't see statistical significance. Basically, that means this kind of negative association can be something random. However, I didn't see, we didn't include another table here, but I want to quickly mention this. Dan mentioned in year 2019, there was essentially there's a sort of corporate governance code adopted in China. And in that corporate governance code, of course, it strengthens the shareholder right further and also, makes corporate governance sort of a more important issue for public companies. And we do have another sort of, regression table, which shows after that change, and this ROA of prior quarter becomes very significantly negatively associated with the chance of success. So basically, the worse the prior, ROA, the performance is, the higher probability that the campaign will be successful. So I think this sort of adds another layer of sort of support to our arguments that in China, at least if we look at the success of these campaigns, there's not random. These are very reasonable results that we will expect from some other jurisdictions that follows the economic and the legal sort of rationales. So that's what I want to show you from these statistical results. And then, so what's in the future? China has just amended its corporate law last year. It started to be implemented last year. And one important change to the law is about the shareholder proposals. Shareholder proposal is probably the predominant form for Chinese activists to launch campaigns against management. So there are several important changes. First, as Dan just mentioned, it lowered the threshold for the shareholder to put forward a proposal. Previously, the shareholder needs to have 3% shareholding. Now it's lowered to 1%. So of course, that seems to be a very important change because makes it easier to put forward the proposals. Second, it was not stated in previous law whether this rule, the 3% threshold, in addition to that, whether the management can put up other sort of barriers for shareholders to make the proposals, like what we saw in the US, the advance notice bylaws. So actually, there was a case a couple of years ago. I wrote on that case, somehow try to learn from the advance notice bylaws by putting in something called like you have to have continuous holding of the shares for, I forgot exactly how many days, maybe 120 days, whatever. And in that case, there was a court decision which said, no, this rule is mandatory. But the law itself didn't say that. The court sort of interpreted the rule as mandatory by saying, okay, apart from this 3% shareholding, no other requirements can be added for the shareholder proposals. But that was not clear in the previous law. And in this new amendment, the law made it very clear. This is the only requirement, 1% shareholding is the only requirement that the company can have for their shareholders to make proposals. So of course, I think both of these things just point to an easier path for the shareholders to make proposals. But there's also another aspect, probably somehow latent, not so obvious. They mentioned a ridiculous case, that happened in, if I remember correctly, in 2019. So there was one public company, the shareholder, put together 1,001 proposals for one sort of AGM or EGM, I forgot, whatever. But by the way, in China, public companies, they have many, many shareholder meetings, not just once. On average, 5 probably. That's the average. So they put together all these proposal. You may ask, were those proposals about? I can show you a series of proposals is about on which day of the week the company should have the break. So you can imagine that will be like 7 proposals, right? So that kind of things happens. But you may ask, why that's the case? This is not put, forward by some random sort of shareholders or activists we looked at. Those are struggling of corporate control by 2 almost comparable shareholder groups. They try to challenge, the incumbent because they are probably second largest, shareholder groups. But the new law changed the way that gives the, management, the incumbent board, some authority to screen these proposals. But it's very loosely said, it has to be related to the corporate operation, certainly not to the extent what we see in the US that the management will have to scrutinize, the proposals. But for these things, what will happen in the future? I think probably the shareholder activism will be, on one hand, probably will be easy. On the other hand, probably it's more orderly. We'll see less that kind of ridiculous things just for, struggle of, the power. And of course, that's my sort of expectation. Let's see whether this will bear out or not. Thank you very much. I'm running out of time. Sorry about that.
So thank you. So now we can take questions. If there's no questions, if there's questions, I would love to take them. Okay, if there's no question, then I will ask Jill 1 or 2 questions. Will people still think about what they may ask? Yeah.
I have questions for you too.
Okay, so we'll do this back and forth. So I guess for Jill, trying to think of this through a sort of a comparative light. 2 things that you brought up, which I would just like to hear your thoughts on. One is you brought up the fact that independent directors, it's always a struggle, right? Especially within Asia, it's interesting because all jurisdictions sort of have adopted this idea of the independent director. And every major jurisdiction has also amended the definition to make sure that the focus of this is actually to police the controlling shareholder. But on the same token, I believe only Taiwan is the main jurisdiction that has put in some sort of cumulative voting requirement or some sort of voting requirement to ensure that minorities get some say, similar to Italy or Israel or different jurisdictions around the world. And I'm just wondering, can you ever see Delaware or the US going in this direction? Because as much as you try to tease out whether or not the controlling shareholder is independent or you use it as a cleansing mechanism, at the end of the day, if the person is elected by majority vote, then it seems to be a bit much to ask them to perform any sort of role. That's one question. The other question is about, would you take the same view on maybe restricting the regulation or at least not putting such hard duties on controlling shareholders if you had a setup like you have in most places in the world where actually the shareholders, like we saw in China, have a lot more power, right? So in Delaware, what you're saying seems to make a lot of sense to me because of the traditional framework that actually you have this safeguard of the shareholders not being able to exercise their power so directly. And the board retaining a lot of that authority provides to me probably one of the most meaningful comparative safeguards. But if you take that away and you look at a Chinese situation, or even you come to Singapore or even the UK, where shareholders actually do have a lot of scope to, call meetings when they want to pass things, to initiate many corporate actions, then would you still have the same view? Yeah.
So those are great questions. First on independent directors. I think you're right. And I think anytime you have a controlled company, you've got some real questions, whatever somebody's nominal ties are, can they really be independent? I mean, when after the Tesla decision, Tesla went ahead and submitted its Elon Musk's pay package for a second shareholder vote. And before the vote, they set up a one-person independent committee that was going to re-examine the compensation decision and decide if it was fair. And that one person, I think qualified under the legal standard for an independent director, but, didn't look like any more independent. And, it was Elon Musk, right? I mean, was it really going to be an independent director? But I think the bigger question goes to, given a company's ownership structure, who's going to be brought in to make board level decisions? And we see this in the US, not just with controlled public companies, but we see this with startups. And you've got venture capital financing, and you've got venture capital funds that have seats on the board of directors. Should they be considered independent or conflicted? You see family-owned companies, and you referred to this earlier, right? It's not just family members, but people who have long-standing business relationships with those family members. But where are you going to go in a private company, right? Who are your directors going to be? You're not going to go and find somebody who's the executive of American Airlines, and they're going to sit as your independent director on your family-owned business, right? So, and I think the idea of what is the supply of independent directors goes to your question about the voting mechanism. Because cumulative voting, and we've had cumulative voting in the United States. California, for a long time, required cumulative voting for non-listed companies. And in all states, it's legal to have cumulative voting. But you still need a pool of directors from which to choose, right? And minority stockholders, unless they can find someone who's going to be knowledgeable and effective and willing to serve, the voting power by itself isn't really enough. Now, remind me what your second question was.
About the setup in Delaware where you have the board playing a significant role, right?
Yes.
And in most jurisdictions, actually, the shareholders play more of a role. So in that type of situation, would you sort of change your view in terms of, say, ironically, there aren't duties, for instance, here on share. People could look at your talk and they could say, well, we should never consider that. But I think the setup is quite different because of the allocation of authority between the board and the shareholders.
So that's the big worry with contractual control, is the law that, and it got a lot of attention at the time, but the law that Delaware passed last year essentially allows a corporation to move from board primacy to giving shareholders a lot of control. And that control, because it's in contracts, is not necessarily standardized, right? You can't look at a statute and figure out how much power a shareholder can have. And you can't really, it's very hard to police that contracting process, right? So the big worry with that statute is that, yes, it's going to open the door to changing this board-centered approach without the guardrails that Delaware has traditionally had. So I think that's exactly right. And I think it's odd that in that debate, nobody raised the question, if we move away from director primacy, should we look to the laws of other jurisdictions in which shareholders can exercise greater operational power? Now I have a couple of questions for you. All right. So one question, and this goes to the recent changes that China made, lowering the standard for shareholder proposals. Texas actually has a proposal in the legislature now that's going to, if it's passed, increase the standard and make, as a matter of Texas law, a requirement that shareholders own 3% before they can introduce a shareholder proposal. Now, that may conflict with the SEC rules. And what's interesting is in this particular administration, the national government is not a big fan of shareholder power either. But the extent to which the SEC is going to challenge or allow something like a Texas restriction, right, seems to be moving us in exactly the opposite direction. And it puts another dimension on this idea of moving from Delaware to Texas. The other question I had is an empirical question, and that it goes to the your results focus largely on whether activist campaigns are successful. But I noticed that in terms of whether activist campaigns are brought, the vast majority of those seem to involve privately held companies, right? State-owned companies are much less likely to be targeted. So it seems like activists are successful, but they're also strategic. And is the likelihood of political intervention something that activists are assessing accurately, and therefore they're refraining from bringing some campaigns that they might otherwise bring?
So maybe I would just, start from the second one. I think it's easier to respond. Yes, I think this is, of course, actually Professor Fisch here just pointing to the selection bias issue, because, we can only see those campaigns that are launched. So those unobservables, we cannot, bring them into our sample. So in our paper, we tried a couple of ways to address that problem, because we cannot address it, directly. So indirectly, I think one thing I remember, we did is to look at the overall sort of, percentage of the SOEs in the listed companies, and the percentage of the targeted SOEs in our sample. And our, finding is they are almost comparable to each other. So, of course, this is not just to say, there's no selection bias, but it gives us a sort of relief, a peace of mind. Sort of, it's likely the selection issue is not that, as some people may say, that's strong. But, I mean, of course, we have to, admit this is something we cannot see. And it's possible that there is some strategic sort of a selection process. You do not target at, those very powerful SOEs at the very beginning. But although we do see a few cases, challenging the sort of the biggest, we call the national campaign, the campaigns, right? So the first question actually, it's about whether it's a direct sort of direction. I think, of course, in U.S., my understanding is there was of course, Elon Musk, he doesn't like, the activists, a variety of things. For instance, that's in, I think the SEC had the power to, for instance, to close the window for the 5% sort of, disclosure rule. Yeah, the 13D. And for a long time, they didn't do it until maybe 2 years ago, whatever. So they did it, right? So, of course, if you don't like, so activist campaign, that's another way to, sort of, to make it harder. But in China, so this shows somehow the opposite sort of mindset of the Chinese regulators, legislators, or even the top sort of leaders, because they want to actually give the shareholders more power. That's, I think, probably it's very clear from, the legislative, process. And you may ask you why that's the case in China. Actually, I explained a little bit in another piece of my work. I have to, the link on the slide, but I didn't mention it. I think one important thing, it's very interesting to see in China why China, I think, probably is a jurisdiction outside U.S. that emphasize the shareholder interest, shareholder sort of, what we call supremacy very much. I think this is not because the Chinese, political leaders, they like shareholders per se, but because China, for public companies, they have hundreds of millions of retail investors. So I explain it as a populist mindset from the political leader, because it's very important to make these hundreds of millions of people happy, at least prevent them from take to the street. So that's a political agenda here. So how to make them happy? Of course, you try to make this stock, sort of market somehow, responsive to their sort of requests. So that's why in a legal process, they want to emphasize the shareholders, especially minority shareholders. You have a lot of power, at least on paper. And from our sort of studies, it's not purely on paper. Because once it's on paper, someone, even if not the retail investor themselves, some institutional investor, they can take advantage of it. They can use it. right? So, but I think the behind the scene, the story I understand it is because of this political agenda to be responsive to those hundreds of millions of retail investors. So that's probably how my understanding of the situation. Dan, you want it?
So I think we're almost out of time, but I see that there's one question from the floor, and since we haven't had one question, I'll just take a short question and a quick response, and then we'll wrap up. Yeah.
Yeah, so apart from the different political agenda in China vis-a-vis Singapore, so what are the broader implications of your paper in terms of its relevance for Singapore, for example? Because even if we increase shareholder power here, the same factors, I mean, I would think the orthodox factors such as the collective action problem, the Asian reticence, which militates against shareholder activism in Singapore. So I don't see that happening in Singapore anytime soon. So why is China so special?
So maybe I'll try to answer this quickly, which is, I think Singapore has the benefit of being a very small jurisdiction. You see in listed companies in the history of Singapore, to just bring up one derivative action, 216A, until a few years ago, there hadn't been a single one even filed against a listed company. And then there was HC Surgical was the first one. That's quite an extraordinary fact. But Singapore has relied on what? On public regulation. And I think the public regulators have done a great job here. But you can do that job effectively, maybe in a country of 6 million people. In a country of 1.4 billion people, I think trying to have the regulator do everything is a pure fantasy. And so I think, yes, Singapore has pulled this off quite successfully, but is it scalable? I don't think so. I think if we grow our market a lot and we get a ton of other investors from everywhere, which of course is an initiative to do that, I think there will have to be some more private enforcement come in. If we keep our market small with a small group of people, maybe you can rely on public enforcement quite successfully like it's been done. But I think China has to go in this direction. I don't think it has any real choice. Thank you. With that, I just want to thank Professor Fisch again for coming to Singapore and giving a wonderful talk, and thank all of you for attending. Have a good night. Thank you. We have a small gift for Professor Fisch, yeah, so thank you.
Thank you.
What's interesting to me, you said it right at the end, that's why you said laws. But of course, for the most part, it's not retail investors that are actually. The extent to which retail investors can get access to company information and actually cast their vote. I mean, like in the UK, it turns out that retail investors often can't get company documents. They can't even get a proxy. Right? There's a whole concept where, and I don't know.
The spectrum, yeah, it's